Welcome to the 31st Annual Rothgerber Conference on Constitutional Rights. I'm Suzette Malveaux. I'm the director of the Byron R. White Center for the Study of American Constitutional Law at the University of Colorado Law School here in Boulder. Can you hear me okay? Right? Good. Okay. I want to welcome everybody who's here in person. Thank you for joining us today, and welcome those who are online as well. This is going to be an important topic, an important conversation. We believe that an informed public is democracy's best defense. When we were brainstorming about a year ago about what the conference should be about this year, there were a lot of issues that we could choose from, right? There were so many things going on in the news. We really sort of struggled, and we were just inundated with ideas. But there were a few things that became pretty clear to us in terms of what are the common denominators? What does all of this have in common? So for many Americans, their faith in the United States Supreme Court had eroded. And there are a lot of reasons for that. It's obviously sort of a complicated topic, but really, if we think about it, it's procedural and substantive, right? On a procedural level, the Supreme Court was increasing its controversial use of the shadow docket when making decisions that implicate the merits. There was a leak of a draft opinion on how the court might rule about the future of abortion rights. There were highly charged political confirmation and selection process. And then we have ethical issues that are swirling around the justices themselves. So that obviously had been leading to extensive study and calls for reform of the court itself because of these procedural problems that were taking place. Now, faith in the United States court was also eroding because of a number of things having to do with substance. So if we think about the disruption of long-standing rights, such as stripping the Voting Rights Act of important enforcement provisions, I'm thinking about the Shelby County case in 2013, concluding that extreme partisan gerrymandering, while undemocratic, was a political question beyond the court's purview. I'm thinking about the Rucho case in 2019, and then almost half a century of precedent overruling the constitutional right to an abortion and calling into question the fate of other substantive due process rights that have been long taken for granted. So, of course, that's the Dobbs decision from last year. So, given the sort of chaos or certainly the crisis going on in the federal courts and a lot of questions swirling around, Americans then thought, well, let's turn to Congress. So we saw some Americans turning to Congress for answers. Now we turn to Congress, and now we look at a Congress where we are faced with one of the most polarized partisan legislatures in American history, itself often paralyzed by gridlock. So under these circumstances, another thing became clear to us. In the face of threats to traditional democratic norms and institutions, Americans were turning to the states to reclaim rights and to seek justice. And indeed, there is a tremendous amount of work that is being done on the part of states all over the country in response to this uncertain landscape that has been created by the Supreme Court and by Congress. Now, for example, Colorado is a good example of that, right? The state of Colorado has really been a leader in terms of carving its own path. Whether it's eliminating qualified immunity for police misconduct, enacting the Crown Act, forbidding hair discrimination, or providing an array of voting methodologies to encourage robust voting, the state of Colorado has been at the forefront of trying to provide leadership and to protect a democracy. This year, we've decided to lean into exploring how is it that states are grappling with this rocky terrain, and frankly, how are states grappling with one another, right? In terms of how do states even interpret and think about democracy are very different when you look from state to state, right? We're here in the United States, it's far from anything but united at this point. So we have all these threats to democracy that keep surfacing, and thus we came up with the topic of state of resistance, the roles of states in the midst of a federal court crisis. So today you'll be hearing from scholars, lawyers, national leaders as we wrestle with what role, if any, states should be playing in response to judicial and political conflict at the federal level. I think this day will have people sort of coming in and out, but it's going to be an interesting examination of a lot of questions that come up, questions of federalism, questions of preemption, questions of what we even mean by democracy as we go from state to state to state. So our program for today, and you have that, please feel free to use the scan the QR codes that are in your seats if you want an electronic version of the program. We also have the good old-fashioned hard copy printouts in the front, so grab that as your guide. We're going to start off today with a keynote address, followed by 3 panels that will be doing a deep dive in 3 different areas: civil rights, voting rights, and reproductive rights. Now, we do hope that you will stay for all of our programming, but we do understand that people have competing demands on their time, so just feel free to pop in and pop out as you can, as you need to. Let me go ahead and get started with some housekeeping matters. We want to note for all of you in person, there will be a Q&A following the keynote. For those who are participating remotely, the Q&A function has been turned off, but feel free to use the chat if it turns out that you have any difficulty with technology, and our tech team will help you. For our lawyers in the house, I'm happy to share that we have been approved for 5 CLE credits. And so, and you can still get partial credit if you don't participate in the entire conference. So be on the lookout for the CLE affidavit that will be emailed to you later. For our students, you are eligible for pledge credits, so I encourage you to take advantage of that. And do look out next week for a survey. We are going to be asking for your feedback. We are always really eager to improve our programming, and we would love your input, so we appreciate that. At this time, I'd like to introduce the Dean of the Law School. Lolita Buckner-Ennis is the Dean of the University of Colorado Law School and also the Provost Professor of Law. Before we were lucky enough to snag Dean Ennis, she was at SMU. She was the Senior Associate Dean of Academic Affairs and Professor of Law at SMU Dedham School of Law. There, she was the University Distinguished Professor, which is an honor that is reserved for the faculty there who demonstrate the highest levels of academic achievement. She was also the Robert G. Story Distinguished Faculty Fellow, and there is a whole list of accolades and honors and things like that that I could go on for a while. So I'm just going to refer you to the program where you can see more about her impressive background. But I will turn the program over now to Dean Ennis, who will make some opening remarks before we go ahead and get started with the keynote. Again, thank you for being here.
Thank you so much, Professor Malveaux. It is indeed an honor to be here with you this morning, especially since we haven't had evidence of the recent sunny weather. For those of you who in Colorado, you know that it's been quite spring-like, and as I am informed, and I'm a relatively new dean and new to the area, I'm informed that this is also spring-like too. And as a result, I completely embrace whatever the weather gives us. I just want once again to welcome you to the 31st Annual Ira C. Rothgerber Conference. You've already heard a little bit about me. Just as a reminder, I'm Lolita Buckner-Ennis. I am the dean here, and I'm in my 2nd year here. Before I go any further, I want to honor and acknowledge that the University of Colorado Law School is on the traditional territories and ancestral homelands of the Arapaho, Cheyenne, and Ute peoples. Further, we acknowledge that the 48 contemporary tribal nations historically tied to the lands that comprise what is now the state of Colorado were certainly here and long came before us. This year, Colorado law students are working on a number of issues with these tribes, and we are so very grateful for the trust that the tribes are placing in us as we go forward in that work. This conference is sponsored by Colorado Law's Byron R. White Center for the Study of American Constitutional Law, under the directorship of Professor Suzette Malveaux, who you've already heard from. The White Center, which was founded through the generous bequest of Colorado Law alumnus Ira C. Rothgerber, serves as the cornerstone of Colorado Law's public service program, engaging law students, lawyers, judges, and the community in our nation's constitutional conversation. I'd like to recognize Suzette Malveaux, who you have already heard from. She is our Moses Lasky Professor of Law and Director of the Byron White Center. Professor Malveaux, as many of you already know, is a nationally recognized expert on civil rights and complex litigation, and her wide-ranging expertise, cutting-edge scholarship, and commitment to innovative teaching and public service enrich the Colorado law community, the campus, the state, and the nation. I would now like to introduce you to our keynote speaker for the day. We are so very fortunate to have Carolyn Shapiro. Professor Shapiro is the co-director of the Institute of the Supreme Court of the United States and a law professor at Chicago-Kent College of Law. Her scholarship is largely focused on institutions about our constitutional democracy, in particular, the US Supreme Court and how those institutions interact. She teaches classes in constitutional law and public interest and policy. She directs Chicago-Kent's Public Interest Certificate Program, and in addition serves as the faculty director of the Constitutional Democracy Project, a civic education project that provides programs, professional development, and educational materials to high school and middle school students and teachers. As you all already know, as you've seen it in your program, Professor Shapiro's keynote will address democratic federalism and the Supreme Court. Let me just say, you know, there's a saying, and I think most of us have heard it, that says to people, I don't know if it's a blessing or a curse, may you live in interesting times. And I suppose you could take that as both an affirmative blessing or an affirmative curse. But frankly, the word interesting has really become almost perilous times for us as we think about the ways in which the norms of democracy or even our Republican form of government are seemingly under assault. I think for many of us in this room, like Professor Malveaux and I, when we were in law school, we understood how this thing works. We understood, generally speaking, the separation of powers, the government, and especially the way that legal norms work. And I can tell you for myself, I never dreamed that I would live through a time when certain of our foundational institutional norms were so much under attack, which again, that sounds like incredibly polemicist rhetoric. And as someone who's a law professor and a lawyer, that's something I did not imagine that I might have said. Because, you know, we are trained to look at both sides of the issue. What is, I think, particularly interesting for me is that we've gone beyond, and I think Professor Malveaux pointed this out, it's not about a side of an issue. It's really about the extent to which or whether we are going to be able to support and advance what we had all, I think, previously agreed were our procedural understandings, our philosophical understandings of what it means to be in a representative democracy, of what it means to be a part of a country where there are states who are the polity of a presumably single federal government. I just sort of say all that as a preface to what I think will be a fascinating keynote and the opening to a wonderful day as we ponder some of these issues about democratic federalism. What does it all mean? And frankly, where are we going? The last thing I'll say to you is that some of you who know me, I often say I'm a futurist, meaning while I am deeply embedded in the here and now, I also consider when anything happens, where are we going with this? What does it mean for 5 years, 10 years, 100 years from now? And so I urge all of you, lawyers, law students, community members, I urge all of you to think about the future and recognize that notwithstanding any particular event that goes on, that's really part of what paves our way to where we expect to be in our future. And so if you care about that, and I think most of us do, I urge you to be not just active participants for those of you who are speaking today, but active listeners and active doers as you go out into the community. So thank you so much.
Thank you.
Thank you.
Good morning. It's such an honor to be here and to have been invited to give this keynote. And I really just first want to thank Professor Malveaux and Dean Innes, but also Charlotte Goodnow and Robin Munn and Linda Lee Bell, all of whom have been so gracious and helpful in getting me here and ready for today. And thank you in advance to the law review editors. My talk today is about the relationship between federalism and democracy, and it's also about the Supreme Court and why the Supreme Court's failure to protect democracy may be actually worse than you think, and indeed argues heavily in favor of significant court reform. But I'm not going to get to that till the very end, so you'll have to stay for the punchline. In this talk, I'm going to try to bring together ideas from overlapping but different literatures and put them in conversation with each other. So I'm relying on historians, in particular of the founding era. I'm relying on scholars of federalism, again, including historians, but also theorists and empiricists, to identify the purposes, benefits, and costs of federalism. I'm relying on scholars of democracy, including political scientists and historians, for insights into how and when democracies descend into authoritarianism and what it takes to avoid or emerge from that state. And relatedly, I'm going to rely on scholars who focus on the role of race in American democracy and history, although I have to confess that their work is so embedded in all of what I'm talking about that in some cases it's just implicit. But I want to acknowledge that from the get-go. And finally, of course, I'm relying on Supreme Court scholars and observers. So to start with a discussion of federalism, or more accurately, our federalism, what we have here in the United States. Part of our founding story that we often hear, and that those of us who teach constitutional law might even sometimes tell, goes something like this. The framers were political geniuses, and when they wrote and ratified the Constitution, they carefully created structures that would resist tyranny, prevent factionalism, and preserve liberty. Now, this story often shows up in discussions of horizontal separation of powers at the federal level, but I'm going to focus on the version of the story that we hear about federalism, what some people call the mythos of federalism. So under this mythos, the framers were fearful of a powerful central government and figured out how to, as Justice Kennedy famously put it, split the atom of sovereignty, preserving state governments that were closer to the people and could be responsive to different conditions and preferences, and therefore preserving liberty. As Justice Blackmun put it, federalism secures to citizens the liberties that derive from the diffusion of sovereign power. Now, there are at least two things about the story as I've told it that are at best half-truths. The first is the idea that our federalism was carefully designed by the brilliant political minds of the framers. I mean, that sort of suggests that our federalism was seen as something of a Platonic ideal by the framers, or as some people argue, it was a carefully calibrated result of deliberations about what amount of sovereignty the states were willing to cede to the federal government. And here's what I think we can say about where federalism comes from and why the story I have just described is a myth. And by myth, I don't mean false in every respect. There are certainly elements of truth, but deeply incomplete. Different people had different views about the relationship and division of power between the federal government and the states. This shouldn't actually be very surprising. Some people wanted a stronger national government. If you've seen Hamilton, you know who one of those people is. Confusingly, from our modern perspective, those people were called Federalists. Their opponents, known as the Anti-Federalists, wanted more power preserved to the states, although exactly what that meant was not clear. As Professor Craig Green has documented, the actual history of the founding era reveals a political society in flux, including its perceptions of statehood, a concept that evolved simultaneously and interdependently with the nation itself, and about which there was significant contention from the beginning. So I highly commend to you his work on this subject. So we have to acknowledge, what we should acknowledge then, is that the Constitution was the result of political battle and political compromise, not Platonic design. But it is also true that it did mark a shift from what came before. Under the Articles of Confederation, which the Constitution replaced, the states could act independently of each other, in just George Washington's words, with unworkable frequency. And the central government lacked basic governing powers, like the ability to tax. Under the Constitution, the central government became more powerful in a number of respects, and that was the point. In the words of James Wilson at the Pennsylvania Ratifying Convention, by adopting this system, we become a nation. At present, we are not one. Now, I would not be doing justice to Professor Green's fascinating and nuanced historical research if I suggested that everyone involved in the drafting and ratification of the Constitution saw it the same way. To the contrary, that is one of his most important points. But it is clear that the Constitution itself takes nationhood very seriously. It's why the federal government is in charge of defense. It's why it has the power to regulate interstate commerce. A single country should not be having trade wars internally, which was one of the things that was happening under the Articles of Confederation. It is, of course, true that states had and have significant power in our system, and that as we understand the Constitution today, there are ways that state power is insulated from federal power. But, and this is one of the critical points, the Constitution is also concerned with protecting the Union itself from the states and the states from each other. Notably, Article 4, Section 4 says the United States shall guarantee to every state a Republican form of government. As I've written elsewhere, although there was disagreement about precisely what a Republican form of government meant, two things were clear. First, a Republican form of government required some form of representative democracy, albeit one that excluded all women, enslaved people, Native Americans, most free people of color, and some white men. So not quite what we would think of as representative democracy today, but it was a necessary element of a Republican form of government. And second, it could not be a monarchy. Now, why? Well, for one thing, the framers believed that monarchies were inherently tyrannical and expansionist, and thus a monarchy in one state, and that was in fact something people thought about at the time as a possibility. A monarchy in one state would be a threat to other states. In other words, the guarantee arises in part from a belief that some forms of government are incompatible with republicanism, and that such incompatible forms of government could threaten the existence of the country as a whole. So, big point here, our federalism was from the beginning, while it was from the beginning underspecified and subject to contention, it was as concerned with national cohesion and functionality as it was with states' rights. So that brings me to the second big myth about our federalism, the idea that it is somehow inherently liberty protecting. The state governments are closer to the people, they're more accountable, diffusion of sovereign power is preservative of liberty. But those claims simply do not describe our history. To the contrary, our federalism was preservative of liberty for some at the grindingly brutal expense of others. More specifically, of course, at the founding, the preservation of slavery was intimately tied to the diffusion of sovereign power. It is not at all clear that the Constitution would have been ratified had it not included protections for slavery, both in the form of express provisions like the Fugitive Slave Clause and the 3/5 Clause, and in structural features like the Senate and the Electoral College that were also attractive to some smaller northern states. That history alone gives lie to the myth that federalism, our federalism, is inherently liberty protecting. To the contrary, not only did our federalism preserve slavery, but well into the 20th century, it enabled and protected what comparativists call subnational authoritarianism throughout the Jim Crow South. Federalism's critical role in maintaining first slavery and then another century of often violent racial subjugation cannot be understated. Now, that's not to say that federalism can't be liberty protecting or that it is inherently autocratic, but it is to say that the existence of dual sovereigns is no guarantee of either. Despite this historical evidence, the claim that federalism is liberty enhancing is frequently made uncritically, without considering what other conditions might be necessary to achieve that end. And here is where I think the framers had something right. Democratic self-government is essential to liberty. The liberty promised by state governments that are closer to the people require those state governments to actually be responsive to the people. Perhaps less obviously, like the liberty-protecting justifications of federalism, other purported benefits of federalism also do not flow inherently from the simple existence of vertical separation of power. Here's how Justice O'Connor, a big believer in federalism, explained its advantages in Gregory versus Ashcroft. This federalist structure of joint sovereigns preserves to the people numerous advantages. It assures a decentralized government that will be more sensitive to the diverse needs of a heterogeneous society. So different laws in different places. It increases opportunity for citizen involvement in democratic processes. It allows for more innovation and experimentation in government. We sometimes hear about the laboratories of federalism. And it makes government more responsive by putting the states in competition for a mobile citizenry. But those benefits all require something more than structure. As Professor David Schleicher has argued, they depend on, quote, the quality of state democracy. Professor Schleicher's argument looks at the extent to which a state's voters focus enough on state-level elections, particularly legislative elections, for those elected officials to be incentivized to deliver the policies that the voters actually want. Too often, he argues, state legislative and other state-level elections are what he calls second-order elections, in which voters respond not to policy positions or past performance, but rather to partisan identification in the context of our national partisan polarization. So to put it more plainly, Republican voters vote for Republican candidates and Democratic voters vote for Democratic candidates, regardless of past or promised future performance. And he says, where state democracy does not produce policies or outcomes that are responsive to preferences of the state, we will see less of the benefits of federalism. So, for example, we will not see the diversity of policies that are responsive to local preferences and conditions. Laboratories of democracy cannot develop effective and popular policies that spread across the country if state-level policymaking is essentially controlled by national partisan polarization. Citizens are less likely to civically engage at the state and local level if doing so is unlikely to affect the nature of the policies that emerge, et cetera. So it's not just liberty that requires a functioning and responsive democracy. Now, what's interesting to me about Schleicher's argument is that his concerns about the quality of democracy in the states are largely unrelated to the concerns of most contemporary democracy scholars. That's not a criticism, it's just his focus is as a federalism scholar. But his key insight that the benefits of federalism all of the benefits of federalism depend on responsive state-level democracies has even more resonance when understood in the context of the challenges to democracy that we see today. So let's talk about those challenges. Now, before I talk about some specific examples, I want to emphasize what scholars of democracy have taught us in recent years. And it's useful to note here, as an aside, that much of the most detailed and informative scholarship in this area comes not from those who primarily study contemporary American politics, but from comparativists and historians. As Professor Jake Grumbach, who has a new outstanding book called Laboratories Against Democracy, puts it, most contemporary American politics scholars had considered American democracy to be so robust that the potential for backsliding made it was unnecessary to study. Now, that's kind of ironic when you consider how recent real democracy actually is in this country, maybe the 1960s. But that blind spot infects not just politics scholars, but lawyers, legal scholars, judges, and justices. What the comparative and historical scholars tell us is that the transition from democracy to authoritarianism comes not through bloody coups, but by using the structures and institutions of democracy against it. Consider Hungarian President Orban's takeover of courts, all done through legal means in Hungary, all done through legal means, but undermining the independent judiciary and protections for individual rights. And the overall point is to use this, would-be authoritarians and successful authoritarians use the structures and institutions, and I would add the rhetoric of democracy, to entrench one party or faction in power, regardless of the actual preferences of the people. In America today, we have numerous versions of efforts to use the structures and rules of democracy to entrench one party in power. Astonishing numbers of bills to make voting more difficult have been introduced and some passed in Republican-controlled states in just this year alone, primarily targeting voters like young people and people of color who are more likely to vote Democratic. Often, these bills are promoted using pro-democracy rhetoric, with promises, for example, of protecting against overhyped fraud. Other entrenchment efforts do not have such fig leaves. Unchecked partisan gerrymandering entrenches legislative supermajorities of one party in states like Wisconsin and North Carolina, whose voters are actually more or less evenly split. But they can also lead to such overwhelming supermajorities in other states that minority voters voices are effectively and sometimes literally silenced. Recent events in Tennessee should remind us all of that. All of these and more demonstrate that we are experiencing not just the threat of, but actual democratic erosion. And what the democracy scholars tell us protects against this erosion is not structure, not federalism, but norms and commitments. I don't mean to suggest that structure is irrelevant or that some structures aren't better or worse at protecting democracy. An example of a worse structural feature might be our Senate. But the norms and commitments are essential. Modern democracy scholars highlight specifically that what makes democracy work is the acceptance that you might lose, and that losing is okay. It might not be fun, because next time around you have the possibility of winning. Entrenchment eliminates the need to accept losing. And again, we have a lot of entrenchment. And I also don't think I need to tell you that we have a lot of refusal to accept losses. So here's where the Supreme Court comes in. The conservative wing of the Supreme Court talks a lot about democracy and political accountability. Just last June, Justice Thomas, joined by Justices Alito, Gorsuch, and Barrett, acknowledged that political accountability is essential to our liberty and Republican form of government. The assertion that political accountability is essential to the preservation of liberty has been at the center of some of the most important and frankly, most disruptive recent decisions of the court. Consider the recent emergence of the major questions doctrine. The so-called major questions doctrine, on which I could give an entire speech, is an entirely invented idea that when a particular law appears to give extraordinary power to an executive agency through either ambiguous or, more importantly, vague or general language, it should not be understood to provide that authority. The justification for this is political accountability. As Justice Gorsuch put it in a concurrence joined by Justice Thomas and Alito in the West Virginia versus EPA case, the doctrine ensures that the national government's powers to make the laws, this was in the OSHA case, national government's powers to make the laws that govern us remains where Article 1 of the Constitution says it belongs, with the people's elected representatives. If administrative agencies seek to regulate the daily lives and liberties of millions of Americans, the doctrine says they must at least be able to trace that power to a clear grant of authority from Congress. In Dobbs, the conservative supermajority embraced the longstanding critique of Roe versus Wade as anti-democratic, repeatedly emphasizing that because, in its view, the right to reproductive autonomy is not deeply rooted in our history and traditions, the issue must be returned to the people's, quote, elected representatives, a phrase the majority uses 8 times. Now, as it happens, as you don't already know, I disagree profoundly with these cases, but I do agree that there is a basic guarantee of political accountability and self-government embedded in the Constitution, and that those guarantees should be a meaningful part of interpreting and applying it. And as I've already argued, functional democracy is essential for the benefits of a federalism to be realized. Yet, when the court makes decisions about democracy and federalism, it doesn't invoke the same kinds of rhetoric. It routinely undermines democracy, allowing and even encouraging entrenchment in deference to a rigid adherence to structure, ignoring the harms that entrenchment does to federalism. So consider Shelby County versus Holder, the 2013 case that struck down 5-4, the most potent part of the Voting Rights Act, the preclearance provision that required certain jurisdictions to get federal approval before making changes to their voting and election systems. Shelby County has had an enormous and devastating effect on democracy, and in particular on responsive multiracial democracy in the previously covered jurisdictions, primarily in the South. But let's look for a minute at Shelby County's reasoning. Chief Justice Roberts' opinion in Shelby County has been widely and justly criticized for relying on a completely new and invented principle of equal sovereignty between the states, identifying the selective coverage of the preclearance provision as its fatal flaw. But in defining the scope of that sovereignty, the opinion says, quote, the allocation of powers in our federal system preserves the integrity, dignity, and residual sovereignty of the states. Quoting Bond versus United States, a 2011 statutory interpretation case. And it reiterates Justice Blackmun's claim that federalism secures to citizens the liberties that derive from the diffusion of sovereign power. Now, all of that language is common in cases involving questions about the scope of congressional regulatory authority in light of the 10th and 11th Amendments. And it's often used to guide the interpretation of federal statutes, as it did in Bond. And in the frequently quoted case I mentioned earlier, Gregory versus Ashcroft, in which Justice O'Connor laid out the benefits of federalism in the process of construing the scope of the Age Discrimination in Employment Act as applied to state officials, in that case, state judges. But importing that kind of reasoning and rhetoric wholesale into cases like Shelby County, cases that address democracy, is another matter altogether. And it ignores the Constitution's commitment in the form of the Guarantee Clause to compatible forms of government that incorporate meaningful representative democracy, and the Constitution's recognition that incompatible forms of government can undermine national cohesion. Now, the Guarantee Clause itself has long been understood to be non-justiciable. That is, that the courts will not adjudicate claims brought under it. But that does not mean it's irrelevant to adjudication. Its promise should inform other things that the court does. In Shelby County, for example, the clause should have informed the analysis of how to honor the promises of federalism. Or consider Rucho versus Common Cause, which Professor Malveaux mentioned, the 2019 case that held 5-4 that partisan gerrymandering claims are non-justiciable. Even the majority acknowledged that partisan gerrymandering is deeply anti-democratic, and principles of federalism should have counseled against ruling it a political question, precisely because gerrymandering so manipulates the political process and undermines national cohesion. So the conservative wing of the court has embraced the myths of federalism, and it has embraced the biggest myth of all, the idea that structure itself can be and is protective of liberty. Or put in terms of the democracy scholarship, it all too often ignores the norms and commitments that are necessary for the preservation of democracy. Instead, it reinforces rigid structures that provide exactly the kind of route to autocracy that we have seen in other countries and in our own history. Now, you might be wondering why I'm putting so much emphasis on federalism and why I am on some level crediting aspects of the arguments made by the dominant wing of the court. Wouldn't it just be enough to talk about how bad the court has been for democracy? And what's all the federalism stuff about? So besides the name of the conference, there are several reasons. First reason is that I actually don't think all of the justices are equally dug in to some of their positions in the area of federalism and democracy. I think some of them are at least open to argument. And I think we saw some of that during the oral argument in Moore versus Harper, the case about the independent state legislature theory that was argued in December, and which I'm happy to talk about in the Q&A. So reaching them requires finding some common ground to start with. The second reason is consistent with the theme of this conference. There is a role for states here. States that value democracy can and should make the kinds of arguments I've been making in numerous settings. State AGs can make these arguments in court. State legislatures can pass resolutions. I am sure that there is a lot of creative action that smart leaders and activists can embrace to push the idea that our federalism depends on democracy. It's not just that we lose the benefits of our modern understanding of federalism, including liberty. When we lose meaningfully responsible democracy, representative democracy, we lose the central purpose of the Constitution itself, a durable nation. Indeed, we find ourselves in a time, this brings me to my last reason. We find ourselves in a time where we hear voices on the right and the left are flirting with secession. As Marjorie Taylor Greene puts it, a national divorce. I never thought I'd quote her in a speech. Now, to my mind, this is unacceptable from both the right and the left. It is an all hands on deck moment. Every pressure point must be pursued. So this brings me to what I promised at the beginning, something to say about court reform. The makeup of the current court is itself a product of anti-democratic entrenchment. I could reiterate the history. Mitch McConnell's refusal to consider President Obama's nomination of Merrick Garland compared with the rush to confirm Amy Coney Barrett, even as people were already voting in the 2020 election. And some of it is a product of anti-democratic structures that long predate the current era. But it's also worth noting that the three Trump appointees are minoritarian in every sense of the word, appointed by a president who lost the popular vote and confirmed with the votes of senators who collectively represent millions of Americans fewer than the senators who voted against confirmation. The anti-democratic composition of the court, combined with its anti-democratic jurisprudence, means that court reform really might be existential. Changing the makeup of the court, in the short run, I would argue by adding seats, may ultimately be necessary for the survival of the union. And if the stakes are that high, it might actually happen. So let's make some noise. Thank you. Should I stay here or sit down? How would you like to?
Okay, thank you so much. A lot of food for thought there. We're going to open up the floor to Q&A. I'm going to start with one of my own and just sort of take moderator's prerogative before we hand it out to others. I was thinking about, unlike other countries or even cultures, the United States and the predominant culture here in the United States really has this almost a hyper focus on individualism, and therefore individual rights that or private rights of action that come out of that. And so I was really curious, as the Supreme Court is rolling back individual rights, in terms of voting rights and substantive due process and reproductive rights, why it is that you think the guarantee clause, right, is a good solution, of the structural solution. Why do you think that that would be effective in terms of addressing that rollback of individual rights?
Well, I wouldn't say that I think it's entirely responsive to that problem. It is, in my mind, I think it has a more limited use, which is the recognition that there has to be some amount of commonality between the way the states operate in order for us to function. And I have an article about this where I talk about how the history of slavery and the Civil War and the Reconstruction era all kind of bear that out. And there's other research that other folks have done along the same lines. It doesn't necessarily mean that we're going to end up with the same recognition for individual rights in every state. There's lots of room for difference between the states and even in how they recognize individual rights under the Guarantee Clause. But the Guarantee Clause provides this quite really explicit recognition that we have to have some things in common to function as a country. What I've argued elsewhere is not, here I'm arguing that the Supreme Court should take it into account in its adjudication of in other areas. I don't think it necessarily speaks directly to something like abortion rights, but it should speak directly to voting rights, for example. In other places, I've argued that it provides Congress with the power to regulate democracy in the states in a much more granular way than most people have recognized in the past. But again, that doesn't intrinsically speak to the protection of individual rights.
Great, thank you, thank you. Josie, I'm going to give you the mic to, oh, you have the mic. All right, let's questions from the audience. Do we have questions from the audience? Francesca.
Hi, thank you so much for being here. It seems unlikely to me that there will be an expansion of the Supreme Court, though I am also hopeful. And in light of that, as the dominant wing of the Supreme Court is sort of eroding democracy by, as you were saying, warping the logic behind federalism and democracy, and as we terrifyingly are trending towards authoritarianism, is it enough for the AGs and state legislatures to be pushing back, and what can we do about that? Is there anything?
No, nothing is enough. I mean, I certainly am not in any way suggesting that my proposals here are remotely magic bullets. There are none. I see this as we are in a situation where we need multiple type forms of activism at multiple pressure points, at the state level, at the local level, at the federal level, in terms of social movements, in terms of voting, in every way. And I don't know which of those pressure points ultimately will bear fruit, or if collectively they will bear fruit. But so I certainly don't mean to suggest that what I'm proposing here is the solution. It's not. It is a piece. So the what else, I think I will refer you to the rest of the day. I have lots of ideas, but I think I will refer you to the rest of the day for people who've been giving a lot of thought to some of the more specifics on those in that area.
You think it's too late?
No. Well, I mean, I can't think it's too late. I mean that quite literally. Like, what am I going to do? What are we all going to do? So no, it can't be too late. I mean, and I think about this a lot, actually, in dark moments, which I have. I think about people like Frederick Douglass and Harriet Tubman and people whose names we don't know. And what they had was a lot worse, a lot scarier, a lot more hopeless than what we have. And they didn't give up. So we don't get to give up.
Other questions? Yes, please.
Hi, I also wanted to ask a little about this guarantee clause idea that Professor Malveaux brought up. I wonder if you think, I like the idea of bringing it into the jurisprudence. Do you think there's a point where we get away from it being not justiciable? Like, it seems insane to me that that part of the Constitution that talks about democracy is not something that the court is able to justice, right?
You know, I thought about that a lot, and I haven't, I think it's plausible that it could become justiciable. To me, the most interesting plausibility, and I actually thought about mentioning it in the talk, but it's a little out there, is the possibility of a state suing each other. I mean, if Illinois is, we're like next door to Wisconsin, right? Poster child for the demise of democracy. And, how does that affect us? It affects us in lots of ways. Things may be getting better in Wisconsin, right? There's just a Supreme Court election that was very amazing. But I think the harms, they do have to be fairly concrete. I mean, I think simply saying that we don't like your form of government. We think you should have more democracy. I don't think there's really standing to well, now, who knows? Everybody has standing if they don't like something. So I think there is room for creativity there, but I don't think that walking into court as an individual is going to move the court to recognize, as individual plaintiffs who say, I'm living under a non-democratic, non-Republican form of government, is where the court is going to recognize that first. I don't know, as I think about, what just happened in Tennessee, maybe there's that kind of overreach. Now that, the just Representatives Jones and Pearson have been reinstated. So whether there was a meaningful harm, I think the court would not really entertain it. But there's other stuff happening in Tennessee. The removal of powers from local governments that are controlled by the opposite party from the overwhelmingly Republican supermajority in the legislature, which became more overwhelming in this last round of redistricting because they could. So, I think there might be creative ways of doing it. And of course, Ruth, let's talk.
Other questions? In the back?
I really appreciate your words. I learned a lot. My name is Autumn Bernhardt, and I guess my question has to do with what do you think the role of like the referendum process and the initiative process is? I actually teach up at the University of Wyoming, and as you know, the state legislature passed a surgical abortion ban as well as a chemical abortion ban. And then the governor referred to sending it back to the people, but it was very anomalous. Wyoming really does not have a very good referendum process. And in a lot of these rural states where these bans are taking place, it seems to be a commonality that there really isn't a good referendum or initiative process. So I was just wondering how that could be strengthened and really how, because it feels like although the legislature does in some ways reflect the beliefs of the people to a certain degree, these are conservative states, it's not the level of conservatism, if that makes sense. Some people generally favor some time frame for abortion, but it's not at the point of conception. So if you could lend some light, I'd appreciate it. Thank you.
Yeah, I think it's a great question. And there's a lot of, there are a number of scholars, Miriam Seifter in particular has been writing a lot about using the initiative and referendum process where they exist as a way of protecting democracy. The problem is what you say about sort of the inconsistent availability of that mechanism. And that in some states where it does exist, where the legislature has the power to do so, legislatures are trying to cut back on its effectiveness, right? By making it harder to get something on the ballot, requiring signatures from all different parts of the state in certain respects, or allowing the legislature itself to undo something that is passed by referendum or initiative like 2 seconds later, which sort of defeats the purpose of having the process. So I think I don't think that a referendum and initiative process is inherently required for a Republican form of government. In fact, to the contrary, the framers certainly wouldn't have thought so. They would have said the opposite. But I think that it demonstrates that a robust form of responsive democracy, there are different ways of having a robust form of responsive democracy, and we can accommodate different versions of that in different states, and it gives people in some states pressure points to push on to demand responsiveness. So it's a somewhat general answer, but thank you for the question.
Other questions? In the back?
Thanks very much for your talk. You covered a lot of ground in a short amount of time and have given us all a lot to think about. As I think about the Roberts Court, one of the things I've been thinking about even prior to the Shelby decision was the quiet way in which so many decisions of the court were normalizing radical outcomes. And I think if you look at the sweep of the court, many of these decisions have been providing a framework that lead us to a situation in which Marjorie Taylor Greene is openly calling for a national divorce. And in some public remarks that some of the justices have given recently, they have said that they are looking back at books and history from the Civil War era and hoping that we're not on that path in light of the divisions. And so I'm wondering about your perspective on the extent to which these decisions, in ways that have the trappings of law and jurisprudence, are creating a larger framework to put us on a path to have the union actually revisit some of the history from more than 100 years ago.
Well, I certainly think that's a danger. I don't think it would look quite like it did. I mean, it would play out differently, but yes, that is one of the things that concerns me a lot. But I also think that possibility is one of the reasons I think there's some reason for hope of reaching some of the justices. And in particular, I'd say just the Chief Justice and Justice Kavanaugh. I don't think they want that to be their legacy, the dissolution of the union. Now, I don't know that they would think we're on the precipice to the extent that some other people do, like maybe me. I mean, precipice, that might be, I don't think we're quite on the precipice, but we're on a dangerous road. I'm sure they don't think we're as far down that road as I do, but they could be persuaded that it's a real danger. And so I think that there is some, and I think we saw this in the Moore versus Harper argument. This was I could talk, I've been talking nonstop for the last year about the independent state legislature theory. So I'm going to try not to get into it in any detail, but I'll say that it's a radical theory that is extremely disruptive, and that some justices on the court are all in on. But at oral argument, both Justice Kavanaugh and the Chief Justice, and to a lesser extent, but to some extent, Justice Barrett, all understood, I think it's fair to say, what makes that doctrine so dangerous. And none of them are going to write the opinion I would write. I think it's fair to say, but I think they heard, I'd like to think, I mean, I wrote a whole article about it that people talked about in the briefs. So I'd like to think that they were concerned about the consequences of embracing that. And Ruth represented me in an amicus brief in that case. That they, me and others, that they recognize that there are serious consequences to some of these decisions, and that they are pulling their punches to some degree. So I'm not without hope on that. It doesn't mean they're going to start ruling in all respects the way I want them to. That's absolutely not going to happen, nor would I expect it to happen. And that's not why I am arguing that we might need to consider court reform. Because that's not, at least in this context, the argument for it.
Thank you. I think there was a hand in the front here. Martha, did you? You're good. Other questions? Yes, please. Casey, go ahead.
Hi, thank you so much for being here. People in this state and at this law school are very familiar with the 303 creative case. And I was thinking about it in terms of your conversation on federalism, about how so many anti-democratic outcomes may come from state laws. Have you seen the court struggle with conceptions of federalism because so many anti-democratic outcomes may be beyond state borders in kind of the technology or rights implicated in the mail-in abortion cases and on websites, things like that?
I think the court adequately struggles with those questions. That what you're describing is some people, federalism scholars call spillovers, where decisions made in one state have impacts on the other. And sometimes those spillovers are very concrete, like, pollution, for example. But I think there are other kinds of spillovers. The most obvious kind is that when you have extreme partisan gerrymandering of congressional districts that affects the makeup of Congress, when there is anti-democratic decisions that might affect the outcome of a state's presidential vote, that affects all of us. Obviously, we saw the risks of this in extreme form in the aftermath of the 2020 election. But I don't think the court fully has, and then in the context of sort of the guarantee clause idea of incompatible forms of government, I think there are lots of other more subtle spillovers that I've talked about in other work. And I don't think the court has focused on that at all. So those are arguments that I think people should be making.
We have time for one more question. Did we have another hand? Okay, in the back, thanks.
As someone who practices in Indian law, I think a lot about tribes as the third sovereign. And I'm just wondering, especially in the secession idea, I haven't really thought about it. How does that really work? Like in a national divorce, does the original trustee take custody of tribes, or is it just unworkable? It seems like there's so many, and especially with the most recent really important cases like Castro Huerta, recognizing a greater measure of sovereignty of the states over tribes. I don't know, is this something you've really thought about?
First, I would say there is much about a national divorce that is completely unworkable, but that is one angle I had not thought about. And I have to confess, I am not knowledgeable about Indian law. It's not an area of expertise, and I would love to learn more about how to think about the third sovereign idea and the role that the tribes play in thinking about sovereignty in this country. But I honestly have not yet. So maybe we'll learn more from some of our other speakers today.
Great, thank you. At this point, I'd like to just give you a round of applause.
Thank you so much.